Yes, kindly join. Today's heading will discuss more in detail about the two parties of the contract. One party who offered and another party who accepted. So the heading today is on offer and acceptance. Already we have discussed so many examples in this regard. We'll talk about two parties X and Y always. So let me have the two parties, the same two parties X and Y. Y, as usual, Y, myself. I'm the owner of the car. Okay, I'm the owner of the car. X, yourself. What I'm doing is I'm sending a mail saying that I'm going to sell my car for 20 lakh rupees. Okay. I'm sending this mail not only to X, I'm sending to Y, not Y, sorry. I'm sending to X, I'm sending to Z, I'm sending to A. So I'm sending this mail to three persons. And you are accepting this offer. So we'll come across three terminologies over here. The person who has started will be called as who has started the offer, who has started the proposal, will be called as the offerer. So in my case, myself is the offerer. Y is the offerer. To whom the offerer gave the proposal, gave the offer, will be called as the offeree. So who are the offerees here? All the three are the offerees. Here, X is accepting the offer. So X will be called as the acceptor. Okay, just think. Before X accepted the offer, Y has sent a mail saying that, okay, ma'am, I'll buy the car. Y has Z. Okay, sorry, Z. Z is sending a mail that I'll buy your car. Now tell me, is X the acceptor now? Who is the acceptor? Z is the acceptor. Okay. Among the three, who is sending the mail first? That person will be considered as the acceptor. In case, so this is one case, okay? Let me have a different, a small change. Z, X, Z and A. All the three are mailing saying that we want to buy the car. Who is acceptor? Who sent the mail first? Will be the acceptor. Here, myself, why I cannot make or I cannot choose who is going to accept my offer. It's because I sent a mail to all the three. You are the three called as offeree. Because all the three has mailed saying that I'll accept the offer, all the three cannot be called as an acceptor that because it is about one car and there's no restriction. If, for example, here, while Y is mailing, he says that I'm willing to sell my car for 20 lakhs. Either you can buy individually or you can join with along with others and buy. Which means what? X, Z and A together can buy now. All the three will be called as the acceptor. What the law says is, what the act says is, when you talk about agreement, how many parties should be there? Please always remember minimum two parties. Minimum two parties. It's not just one party offer and another one party accepting the offer. No, not such way. It can be more than two parties. So always try to remember this as minimum two parties. So here, for convenience sake, let me take that X has accepted the offer. X has sent a reply mail saying, I'll accept the offer, which means he becomes the acceptor now. Okay. And hope you remember when we were defining in the very first topic about offer, there is another one word we used. You remember? Offer or what you call as? Proposal. Yeah, thank you, Pa. Offer or what you call as? Proposal. Only this offer or proposal is accepted by the offeree, then this will become a promise. Okay. Only after it becomes a promise, we'll call this person as the offerer. That is, the relationship comes only after this. This person as the offerer and this person as the acceptor. So hereafter, throughout the Indian Contract Act, will not say that there are two parties. We'll say that two parties names as offerer and acceptor. So during your exam also, you have to use these words, offerer, acceptor. If you're writing answers under the Indian Contract Act, please use these two wordings, offerer and acceptor. So in between, if you talk about the offer given to that those respective person, you can use the term offering. Okay. Let me go for the singer material. Please join. Actually, it's somewhat a big topic. Let me go in a slow-paced manner. Offer, which means it's a proposal. See, this word is important. A proposal. There should be minimum two parties. There is no such one party to one party itself. So, by one party to another, there should be an intention also. Please highlight this term. Intention means his intention to sell. Then only you can say the agreement is legal binding. This person will be called as the offerer. If it has been accepted, he will then become a promiser, or you can use the term called as proposer, the person who makes the offer. Offering or promising, the person to whom the offer is made. Please place a star mark. He need not accept the offer. He need not accept the offer. Acceptor, the person who accepts the offer. And what is the term acceptance means? The concern given to the offer. Do you remember one of the essential concern of the party should be free and genuine? When we say the consent is nothing but a word talking about the acceptance. Okay. So offer by definition it's a proposal by one party to another party. Let me go for the example. Let me go for the second example. A teaches his parrot. A teaches his parrot what it teaches. What he teaches to recite an offer. What do you mean by recitation? Whatever the words are used without any change, without any meaning change or word change, you have to just repeat it. That's what I call as recitation. Reciting. So A teaches his parrot to recite an offer and then sends the parrot to B. The bird repeats the recitation. It's a valid offer. You can please make a note of it. It's a valid offer. Okay, it's a valid offer. What about the first one? X says to Y, will you purchase my white horse for 12,000 rupees? It's like asking a question. Yes, because it's not a promise. You cannot make a promise, right? Only after acceptance it becomes a promise. What's the question? What X says to Y? Will you purchase my white horse for 12,000? Yes, it's also a valid offer. Next, we'll go for classification. Probably you can go for this chart work. Can you please start with the chart work? Classification of an offer. So you can just have the heading as offer. Now we'll go for separate classification. First one, first classification. Express offer, implied offer. This is falling under first classification. Express offer, implied offer. You have to relate this with the classification of contracts. We were dealing with the first topic with respect to formation of creation of contract. You remember how the contract is formed or how the contract is created? By express or by impliedness. If the offer is an express offer, then the contract will be an express contract. If the offer is an implied offer, then the contract is going to happen as an implied. That is circumstances or by the conduct of the parties. So express means words written or it can be oral. So words means oral or written. So this is first classification. Let me finish off all the offers, then I'll go for the example point of view. Okay. Second major classification is to whom this offer made. We say this term offeree, right? Who is this offeree? If the offeree is any public at large, you'll call this as general offer. If the offer is made to one particular person, only that person only can accept. For example, myself, why I am offering to sell my car to you, only you, which means that one specific person. Myself, why I am offering to sell my car to you, to Mr. Z, to Mr. A. All these three are specific person. Specific person means not one person alone. To that specific group also it can be. But what happens to the general? It can be to the whole of India, whole of anything. Okay. So this is second classification. This is based on offering. Who's the offering? Based on offering. Can please make a note on this. Based on offering. If the offeree is a general public, then you call this as general offer. If the offeree is a specific person or a specific group of person, or probably we'll call it as ascertained person. Ascertained means what? We'll prescribe some qualification that only he can accept it. Then we'll call this as a specific offer. Okay. So let me write it over here. What's the first classification? Express offer. Then second is implied here. Then second major classification based on the nature of the offeree. You can call the offer as general offer or you can call the offer as specific offer. Okay. Let me go for the third category. Third category is a unique case where we use a term called as counter offer. Myself, why? Let me try to stick with the same example. If necessary, I'll change the person's name. Okay. Myself, why? I give an offer. I send a mail. The same example, Bob. I send a mail for selling my car for 20 lakh rupees. To whom? Let me go with X itself. Yourself X. What you have to do? If you want it, you can say, yes, I will buy. If you don't want it, you reject the offer. That's it. Only this you can do. Only two options for you. But instead, you feel like this 20 lakhs is a bit heavy. Which means what? It's overpriced. Immediately what you do here is you send a mail not for directly accepting it. Acceptance goes with one single word saying okay. If you are okay with all the terms and conditions, okay, if you are okay with the money, if you are okay with everything, certainty and everything, then you have to say okay. But what you feel now? The amount is, see, usually even to an auto driver will bargain. Right? This is the habit. Even to an auto driver will bargain. But this is about a 20 lakh car. Why I need to directly pay and come? So let's ask for a small discount. What X immediately does here is, this car seems to be overpriced, or you need not give the reason. I'm willing to buy the car for 15 lakhs. What Y said? What Y said? 20 lakhs. What X is now saying? 15 lakhs. What Y is going to do now? If it is 19 lakhs, I will give. Okay. What X says? Okay, I'll buy it for 19 lakhs. See, just I'm giving a rough figure. It can be anything. He may be saying that, no, I cannot give for 20 lakhs. Then again, X may be saying that, okay, I'll buy for 16 lakhs. You try to give for 16 lakhs. Then again, Y will be saying, no, I'll give only for 19 lakhs. This is how it will go. How you discuss with how you bargain with the auto wala, the same thing that is being done here also. Now come here. When we say Y has sent a offer, X has not accepted it, which means there can never be a contract. Please try to understand, it's very, very important. First, who started? X started by a mail. Okay. What X has to do, sorry, Y started by a mail. What X has to do? If he wants or if he's willing to buy the car, then he has to say the acceptance, okay, I will buy it. But this doesn't happen. What X is doing? He is trying to bargain with 15 lakhs. When this happens, this will never end in a contract. There can never be a contract. This is over. This is over. Here, who's the offerer? Coming only to this case. Who's the offerer? Y is the offerer. Who's the offering? X is the offeree. He did not accept it. You did not accept it. So there can be an acceptance here. There is no acceptance. So X cannot be called as an acceptor. Only if we talk about offer and acceptance, we can talk about a contract. There is only an offer, there is no acceptance. So we can never say it's a contract. Okay. If you again ask me, is this a counter offer? Yes, because if he says no, there is no contract. But what he says, will you give the car for 15 lakhs? Now the sequence. Now X has started saying what? I will purchase a car for 15 lakhs. Okay. To whom? To Y. Okay. To whom? To Y. Now X becomes the offerer And you will not directly call this an offer. Instead, you will call this as counter offer because it's not directly started from X, right? From whom it started? The earlier situation, the earlier sequence of events. It started from Y. He started saying that he will sell it for 20 lakhs. Now he's giving a counter. Who? Yourself. X. How much? Any one single penny rupees less than the original offer will be called as a counter offer. Even though he's asking just for 90 lakhs and 50,000, even though he's asking for 19999 or whatever it is, just one penny less than the original offer amount will be treated as counter offer. Okay. Here, X will be called as the offerer. Who's Y? Offeree. What do you mean by the definition offeree? To whom the offer is given. X is giving the offer to whom? And please remember, offer is not alone selling. Offer is somewhat buying also. We are not talking about buying and selling. We are talking about giving some proposal. So X was giving a proposal saying that I will sell my car. Y. Now X is giving an offer saying that I will buy your car. It can be selling or it can be buying. Only after the sale takes place, we can say he's the buyer and he's the seller. Okay. So who is the offerer here? I'm over here. Who's the offerer here? X. Who's the offeree? Y. In case he is not accepting it, Y is not willing to see. The car is 20 lakh rupees. He is asking for 25% discount, 15 lakhs. How can I sell it? He says, no, I'm not going to sell it. He's not saying okay, which means it can never end in contract. None of. In case Y tried to bargains, he says, I will give it for 19 lakhs. Anyway, this is not going to happen. This is not going to become a contract. If Y is offering, that is, Y is asking for 19 lakhs, then it starts with Y now. Y asks for 19 lakhs. Y becomes the offerer. And to whom he is offering? To the same old person, X. X becomes the offeree. Okay. And whatever it is, he may be accepting or whatever it is. And still, this will be called as the counter offer only because it's not directly from Y. It's because of X words now, Y has changed. If you go for the very first sequence, what happened here? The very first sequence, very first mail. This alone is the original offer. What do you call this one as? Original offer. All the forthcoming cases, you will call it as counter offer because it's not directly from the original offer. It's a sequence of events or sequence of the things happening from the original offer. Is it okay? If you want to make a note of anything, you can please make a note of anything. So this is about the third heading called as counter offer. Yes, please. So let me categorize this as third one. Okay. Then cross offer. What do you mean by cross offer is? I'm sending a mail saying that I will sell my car for 20 lakh rupees. At the same time, you send a mail, okay, asking me to sell, which means you're willing to buy my car for same 20 lakh rupees. You know that is same. Okay. See, mail, sell, buy. One person is willing to sell, one person is willing to buy. What is the content here? What is the subject matter about the car? In case if I have two cars, two brands, okay, one BMW and one Audi. You are asking for BMW. I'm also willing to sell BMW. See, what a coincidence. Say for 20 lakhs, 20 lakhs. It's a 1 crore rupees worth car. I can sell it for 50 lakhs. It's because I'm selling to X, I'm selling it for 20 lakhs. And you are asking me the same 20 lakhs. Okay. In this case, it looks so very beautiful. There is a good wavelength between X and Y going. But what law says is it cannot be a contract. See, you're all law students. You should not think this logically. Same wavelength, ma'am. I thought I can buy it for 20 lakhs, the BMW car which you have, ma'am, and you also willing to sell? Immediately will process. But law says this is not a contract. Why? For a contract or for an agreement takes is the very first thing, there should be minimum two parties, not about two parties alone. One party to offer and another party to accept the offer. See, hereafter, see, Till the last session, we were talking about two parties, and two parties. If there are two parties, it's a contract. But now we have to go for the next angle, saying that the two parties is one party who are offered and another party who has accepted. Now here, if we say that in my point of view, Y, who is the offerer? Myself. X becomes the offering. But if you go for the X point of view, for the same contract, for the same subject matter, for the same conditions, and etc., etc., X becomes the offerer and I become the offering. See, how can we both be an offerer and an offering? So law says it cannot end in a contract. But practically, we'll finish the contract and we'll go. That's different. What law says? It's not a contract. So that's about the seventh one, cross offer. So probably here you can list it out. This is the third one, right? This is the third one, which we were discussing on counter offer, and second one, cross offer. See, why I'm classifying in this way is in both the cases it will not go as a contract. A contract will never be formed. Last one, the fourth category is what you call a standing offer, which means I'll give you the offer and it will be open for a particular period of time, probably 1 week. I may be mentioning, or some reasonable period will be there. So before that, you have to accept it. This is what I call as standing. Okay. So we have totally, this is actually 6 and this is 7. Totally have 7 different types of offer. The alternate names for standing offer is open offer, or what you call as continuing offer. Can you now go for the example point of view? I have discussed what is what. I have given the explanation. Hope you could have understand. If not, probably discuss the example point of view. Then we'll go for another theory. Okay. Yes, please. Just go for the examples from the beginning, from the express offer. Try to understand these concepts from the example point of view now. X says to Y, already we have discussed this, right? Will you purchase my white horse for 12,000 rupees? He's clearly expressing his intention by through words. We call this as express offer. Second example, boarding in a metro rail at metro station, which means it's a conduct. You have taken the ticket and you're boarding the station, or you're boarding a bus, or whatever it is. It's by your contact. It may be a body language, it may be the moves you make, can be anything. It's an implied offer. You remember we were discussing one example in the earlier topic, M moves, L's lawn. Probably remember which question is that. Can you please turn over that to that page? Yeah, here. This ninth one, page 2.8. Can you please turn over? M mows L's lawn without being asked by L to do so. L watches M doing the work but does not attempt to stop him. Okay. This is also somewhat like a body language. Not interfering, being silent. Continuing. General offer. Example. An offer to give reward to anybody who finds the lost horse. I have a pony or I have a horse. I lost it, horse or dog. Most of the time, the exam questions will have dog, this car, pony, horse. Whether it's a pony or horse or dog or car or whatever it is, I lost it. And I'm giving a pamphlet all over my area. I'm sticking in the walls and all. Okay, saying that if anybody gets my lost puppy or lost dog or whatever it is, okay, I'll give them reward. Okay, if this is X and you find my dog and you come and return it to me, obviously, then you will get the reward. Here, please make a note here. Offer is there. To whom it is offered? To anybody who finds the lost dog, lost horse. Is that you X accepted the offer? No, you did not accept the offer, but you find the dog and you brought it here. Okay, you find the dog and you brought it here. Law says this is also a valid offer. This is also a valid contract. See, so far in the case of counter offer, we were saying there should be an offer, there should be an offeree acceptance, and so on. If this is not happening, this cannot be a contract. But what law again says here is, in the case of general offer, offeror communication is sufficient. Offerees or acceptors communication is not necessary, because it's a very large number of people over there. Anybody can accept it. Whom we are going to say who has not accepted or who has accepted, right? So you have to place a star mark over here. It may look like there is no offerer, there is no acceptor, but what law says is yes, it can be taken. Law says it because law says we are accepting it as a valid one. Okay. I request you to take this as a home assignment. Carlyle versus Carbolic Balls Limited. I'm not discussing now because only after finishing the whole topic you'll understand in a better way. So I'm not going to confuse you here. I request you to do a detailed study. Carlyle versus Carbolic Balls Limited. Let me go for the fourth example. Under the specific offer, A offers to sell his car to B. To whom? To B. Which means B is the only offer. B can only accept the offer. B can only be the acceptor. So it's a specific person or to ascertained person. Ascertained person is here is with the ascertained person. Only that person. It can be one person or group. That's different. But to that person only. Counter offer, we have gone in detail, but still let me go for the example. A offered to sell his car for 20,000 rupees. I remember I gave 20 lakhs. Okay, it's 20,000. B replied that he can accept it for 17,000, which means he's countering the offer. Which means original offer cannot be effective, cannot be active now. So it gets terminated. Please highlight this term. Original offer will never become a contract. It will get terminated. Offeree accepts subject to certain conditions or qualification, not accepting, which means terminating the original offer. Terminating the original. Very, very important part. Shall I turn over? Cross offer. Example, A offers by a letter to sell his car to B for 15,000 rupees. B, at the same time, offers by a letter to buy A's car for 15,000 rupees. The same. I was discussing with 20 lakhs. This is the same with 15,000. Same. It will be ditto. Only difference is one will be the seller, one will be the buyer. One will be saying of selling, one will be talking about buying. Only that difference will be there. Other things are the same. Here, the two letters cross each other in the post, and this happened in this case called as Tin versus Hoffman. See, we are following English laws. So you cannot write Marasamy or Munasamy. You have to write Tin and Hoffman only. Okay. So Tin versus Hoffman. And please make a note of this one. No contract will exist as nobody can be called for. See, who is giving the first promise? Offerer or acceptor? First promise is given by the acceptor, saying I'll buy it. Only after acceptance is done, offerer, that is offer or proposal becomes a promise. So once a contract has begun, which means after acceptance has now a promise. Offer has now become a promise. So both the promise will be equally valid. If the other person, offer, is not accepting it, the proposal given by the offerer will never be considered as a promise because there is no contract. Only when we talk about contract, we are going to talk about proposal, we are going to talk about promise and other things and performance of a promise and all. Okay. So here, we cannot call the offer, when it comes to be a cross offer, we cannot call it as a contract as nobody can be called for it because who will become liable? Okay, who will become liable? The liability is now a question mark. Right, understand? Offer and author, the definition clear. So it should be very clear that who's going to call for the offer. There is call for the offer is who is going to perform in the order. Who's the first performer? Okay. Then the last one, example on standing open or continuing offer. We invite tenders, share applications and all. It will be open for a certain period of time. Only after that it will get automatically closed. So it will be open for acceptance or reasonable time. Is it okay? Shall I carry over? The next important concept on invitation to an offer. I go to a shop. Okay. I like eating Arun ice creams. You like eating Arun ice creams? Or you like eating ice creams? What ice creams? You can tell any ice creams. It's not going to affect my case law. Any ice creams. I go to an exclusive showroom of Arun ice cream. I see there is a box which has all the ice cream. Okay, probably before leaving to the shop, I might be thinking, okay, I'll go for this butterscotch. And after seeing that big box, I'll get confusions. Whether I go for chocolate or double chocolate or butterscotch. Okay, or I'll go for this kuchi mithai like, okay, with a stick. At last, we'll decide. First, let me go for butterscotch. Then second one, I'll go for second one. So how many of this type? I see this box containing all the different of ice creams and I choose one. Okay. Then I pay. Obviously, I'm a genuine customer. I'll pay and I'll eat. Here, leave off all these things, what is happening in the contract. Just imagine you are in the shop. Imagine you go to a shop. So how the shop will look like, whether it's Arun ice cream or whatever the shop, it will be properly displayed. It will look so very attractive for you. They are not asking you to buy. You are going and buying. Please understand. They are not asking. Obviously, they are keeping all these ice creams and other varieties for selling only because they're business. What contact tax says is they are displaying the goods. Okay, which means we use the term called as the shopkeeper is inviting you to offer. When there is a display, there is no promise. It can never end in promise. When you ask for butterscotch, okay, whatever the variety is, I'm just mentioning as butterscotch, which means I am offering, and if butterscotch is not available in the box, then it can never end in contract. Immediately, what he says, the shop owner, I'll keep the name as SO, shop owner. The shop owner says, no butterscotch available, ma'am. Just now the shop got over. Is this going to end in contract? Now just tell me, if the display is considered as offer means, then once it is accepted, it will become promise. This can never happen in this case because even if it is a display, probably if there is one butterscotch in that box, that might have brought by some other person. Even though there's a butterscotch in the box, he cannot sell it to me because it's already been sold. So displaying of goods, seeing the list in the menu card, and you might have seen some dolls being placed with this glasses and all, and this price tags will be hanging in the glasses, in the dresses, in the t-shirts, the pants, and all, in the shoes, and the handbags. Okay, all these are considered as not offer, instead invitation to an offer. He says there is no butterscotch available, so there is no contract. Then I ask for go for double chocolate. Yes, he gives me one. Still, the shop owner is the person who invited you to offer. You only went inside the shop. You want to have ice cream. You asked for double chocolate, which means you gave the proposal. If it is accepted, it's going to become a promise. So you are called as the offerer. Okay, you're willing to buy this double chocolate. And he gives. How he gives? By writing a letter? How he gives? That's why I'm asking you to imagine the shop. He opens the box, okay, sliding the door, and he takes one and give it to you in hand. Which means what? He's accepting the offer. There is one small difference. A small difference means one small specification or one small special case where it can never be a general offer. To whom you're offering, to whom you're selling, to whom you're saying that I'm going to buy this ice cream. To all the public? No, to the shopkeeper. So that this can never be a general offer. This can only be a specific offer. Who's the specific person? Only the because he is the person going to sell. He is doing his business. Okay. Yes, come here. Invitation to an offer is like general information or public notice given to the public to initiate the offer. Okay. Let me go for the example before continuing this content. Shopkeeper's catalog of price, display of goods in a shop, all these are considered as invitation to an offer. But why we call this as not an offer or something like that? Because there is only one party. When we talk about proposal, then there is going to be another party coming inside the role. But when we talk about invitation to an offer, there is only one party. You might have seen in some shops, only the shopkeeper and employees will be there. No, no customers will be there, right? There will be one party in the question. There is no question of communication, no performance of invitation to an offer, no formation of contract, nothing. Okay. You just go for a long walk. Just imagine, please try to imagine all this. Please try to picturize. If you want, you can close your eyes also. You can go for a small sleep and come. Already we are in that state only, ma'am. At least you knock your head, saying you're not sleeping. You just go for a long walk, you along with your friend, okay? And you feel like eating something, notifying something, okay? Immediately you see a tea shop. Okay, you just want to have a chat with your friend, sit somewhere and stand somewhere, and you want to have a chat with your friend. At the end, you don't want to go home. That's it, right? Okay. So what you're doing? You're having a tea. There is a tea shop. There is a Arun ice cream shop, and it's a very hot climate, and you're walking for a very long distance. At least you want to stand somewhere and have a good chat with your friend. So immediately, what you're doing? Tea shop or Arun ice cream? Okay. Yes. For one, it may be tea shop. For one, it may be Arun ice cream, depending on the budget in the hand. See, all the shops are open. You are only preferring to enter. Please try to understand. All the shops are open. You are only preferring to enter, or you are preferring to choose which one you like, is what you call as the offer. All the shops are open. Everybody have the menu card. Everybody have the display. Everybody have the display goods. Everything is there. It's applicable for both the shops. They are inviting you to offer. They are not offering. Okay. So that's about. It's a very beautiful content invitation to an offer. Can you just please go through? Can you please tell me two examples where you have personally faced this case? Probably might have gone to a shop or visited somewhere. Can you please tell me? Next heading. How we say a contract to be a valid one, we need to have 10 essentials. Same like for an offer to be a valid one, we need to have the following as the essentials. Very first point carries from the definition. You should need to have an intention to create legal relationship, which means it's a direct point saying that legal relationship should be there. Second, certainty should be there, definiteness should be there, and it should not be vague. Directly, this is leading to the point certainty and possibility of. See, all are one single point. We are seeing in different angles. You remember the ninth essential, as we discussed in our list. A certainty and possibility is one of the essential for a contract to be a valid one. That contract to be a valid one, but that point is coming from this essential only. When we say offer is express, then the contract will be a express contract. When we say an offer is having the clear certainty, definiteness, and everything, then obviously the contract is going to be a certain contract. So, right? It can be specific or general or express or implied. And fourth one, very, very important, it should be communicated to the offeree. Should be communicated to the offeree. Let me go for the example. A intents, usually things, will not use like these words and all things or something like that, because we need to have this word called as intense. So if you are about to give an example of your own, please try to give these words, include these words, intense, which means what? There is a clear intention of creating legal relationship to fulfilling the promise. A intends to make an offer to B and tells C about it. A intends to make an offer to B, but he's not directly doing it. Instead, who is one person in between here? Tells C about it. C informs B, so it's not directly, it's through C. C informs B of the contemplated offer about A. Himself does not communicating the offer to B. Here B accepts the offer and informs A about the acceptance. There is no communication. Please highlight. You may ask me, need not be directly to B, but C is involved here. But why there is no communication and why this is not an offer? Because A just told, I'm willing to what? Make an offer. I did not tell to C, go and tell this to B. Please try to understand. I was telling C, I'll give some names. Myself, Y. Okay. Shreyas is there and your ex. I told you, no, I'll remember your name. So I'm trying to remember. As you know, you're always X, right? I'm willing to sell my car to S, but not directly I'm saying, but what I'm doing, I'm telling you, I'm not telling you to convey to Shreyas. Please understand. I'm telling that I have a plan, I have an intention to give my car to Shreyas. I did not ask you to tell you to Shreyas. Please remember, I did not tell you to ask you to tell to Shreyas. But what I'm doing, I'm just sharing, saying that I have this intention. But what you did, directly told, ma'am told me that she has an intention to sell the car to you. So, are you willing to accept the offer? All these are not necessary and these are not as per the law. See, here's a line. I want to underline this one. Let me reload the page. See this line? Himself does not communicate the offer to be he himself. So, is that Y has to communicate direct to S? Not necessary, but if it is through X or A or B or X, it should be properly communicated to X, saying that you have to go and communicate to Shreyas. Okay. Note, but there is an exemption where general offer and communication to an offeree can be taken out. If it is a general offer, it need not be communicated to the offeree properly because when we say general, it's public at large. There are so many persons coming in. I'm saying I lost my dog. Immediately, I'm putting up pamphlets. Am I communicating to everybody? Everybody are watching that pamphlets? No. Everybody are aware of the pamphlets? No. Anybody who found the dog, anybody who are aware of that will be taken. Fifth one, so you can refer this case also. So already I gave an assignment, right? Which was the case I asked you to refer? Carlyle versus Carbolic Balls Limited. Okay. Then second case, this Gauri that, okay. Lalman Shukla and versus Gauri that. Fifth one, the promise or the proposal or offer need not be on positive acts alone. It can be for negative acts also. You remember to do or not to do. Acceptance. It is immaterial in the eyes of law. Law says only for doing this one you have to consider no, there is no prescribed rights and duties. Let me go for the second one. A makes an offer to B. On the other hand, when A asks B after the car meets with an accident with B's scooter not to go to the court of law. It's my mistake only, don't go to the court of law. I will go for paying the repair charges and all. So, which means it's something about not going to the court of law. Okay. Sixth, it should be made with made with a view to obtain the assent of the offering. See, my car is, I'm fixing the car for 20 lakhs. Okay. Actually, the car's worth is 10 lakhs only. Which means what? My intention is not to sell, it's not a genuine one. Okay. So, it should be made with a view to obtain the assent of the offering. Can you go for this example? Continuing on. Here, A tells B that he desires to marry by the end of 2017. It does not constitute an offer of marriage by A to B. Okay. Therefore, to constitute a valid offer, expression of willingness must be made to obtain the assent of the offer. When we say it's an offer, when the proposal is accepted. Else it will be just an offer only. We don't know whether this girl, girl or boy, whatever it is, whether it will be accepting or not. So how can you say it's a valid offer? You call that as an offer. See, we say contract and void contract. The same way we say it's an offer, but it's not a valid offer. To give a name, we say it's an offer. Okay. Seventh one. It should be very clear whether this is an offer or invitation to an offer. Okay. We should be very clear. This is an offer or invitation to an offer. I request you to refer all these three cases. This is directly relating with the point invitation to an offer. So you refer these cases. I'll discuss a bit later. Okay. There should be a proper term for compliance and all, probably giving some advance amount or whatever it is. If there is no such thing, it cannot be a valid offer. And the statement of price is not an offer. What is the statement of price? Price tag. Statement of price. What is that? Offer or session to an. So totally 9 plus 1 point. For a offer to be a valid one, you need to have 9 points. Okay. Shall I take over? When an offer lapses, I said I'm willing to sell my car for 20 lakhs And you please give your concurrence by the end of this week, probably on Sunday. I'll wait till Sunday. Which means what? You have to give your concurrence before. You have to give your acceptance before Sunday, right? This is open for some 3 or 4 days only. First point, communication of notice of termination. This is revocation. Revocation means taking it back. What do you mean by revocation? Taking it back. This communication of notice of termination also has to be given up to the offeree. See, earlier point we were saying that it has to be properly communicated to the offeree. If I'm withdrawing my offer, it also should be properly communicated to the offeree, right? I'm saying that I'll be selling the car for 20 lakhs. Before you accept it, I don't want to sell it. I don't know. There may be some personal reasons of my. I don't want to sell the car to you. Okay. Please remember, I gave you to give the acceptance before Sunday. Okay. It is today, Friday. I am sending a note that I don't want to sell my car. And you did not accept it. Because if you accept it, means it becomes a promise. Then there is no other good. I have to fulfill that. On Friday, I am sending a note. I don't want to sell my car. Okay, which means what? We'll say this as withdrawal of offer, but this is not the legal term we are going to use. Instead, we'll use the term as called as revoking the offer. If revocation is valid, then what law says is there is no offer at all. Now tell me, if there is no offer, can we talk about acceptance? If on Saturday you send a note, I'm willing to buy your car, ma'am. You're willing to buy the car. See, there is no offer. Then how can you talk about Saturday's acceptance? It has been properly revoked. Let me go the other way. On Friday evening, I sent a note saying I don't want to proceed with the offer. I want to revoke it. But on Friday morning itself, you have sent a note to me saying I accept it. Okay. Which means what? It's a valid offer. It's a valid acceptance. It becomes a valid contract. Revocation becomes invalid. Because once acceptance given means contract started. If you're not fulfilling the contract, it goes in breach. What is breach? Non-fulfillment of promise. Okay. So these all contents relate to revocation of offer term. So let me come again with the point bit later again. So second one, lapse of the specified or reasonable time. So I'm just keeping it for Sunday and you're not accepting it. Death or insanity of the offer. What do you mean by going insane? Becoming lunatic. Okay. Which is losing the mental capacity. Counter offer, yes, already we have discussed counter offer will never end in a contract because it is terminating the original offer. You have accepted, but not in the prescribed or usual mode. This is a beautiful point. See, I sent myself why I sent through a mail and asked you to reply the acceptance through a mail only. But what you did, you come directly to me and you say that, ma'am, I'm willing to buy the car, ma'am. No, it's not an acceptance. Please try to understand. Ma'am, I'm directly coming to you and telling that I'm willing to buy the car, ma'am. No, what law says is, in what mode why asked you to accept? Sending a reply mail? You're not sending a reply mail means it cannot be taken as an acceptance. Law says it has to be accepted in the prescribed or usual mode. But obviously the other way is going to happen. I'll accept it, okay. Because I know about you, you know about me, we'll accept it. But in case in future, yourself X, you're not paying the amount. And I go to the court of law. Because it's a legal contract, because a legal agreement, I can go to the court of law. I go to the court of law, I file a case. I'll file a suit, sue on you. What the judge will say, ma'am, this is not at all a contract, ma'am. Why? See, ma'am, there is no reply mail received from X. Please try to understand. The judge will directly look into Indian Contract Act. The judge will check whether there is an offer. The judge will check whether there is an acceptance. What's the offer? Sending a mail. What the mail is said. Are you willing to purchase my car? How it has to be replied? How it has to be accepted? By sending a reply mail. The judge will clearly say there is no acceptance, there is no contract. Then why are you suing here? You cannot file a suit because there is no contract. It's void contract. See, there should be an offer and acceptance. There is no acceptance. But I'm saying, sir, we had a meeting on Sunday, sir. He directly came to me. He said that he will purchase. So I gave the car, sir, and he's not giving it. No, ma'am. There is no acceptance, ma'am. He'll say the only point because acceptance should be in the prescribed or usual mood. Okay. What do you mean by usual mode is everything. Sometimes you go some for online payment, immediately get a receipt or acknowledgement. That's what you call as the usual mode. Okay. Non-fulfillment of a condition precedent. In case if I am asking you to give some advance money, the car is 20 lakhs because I need to hold you for your purpose. Kindly pay 1 lakh as advance. Then I'll hold it. This has to be done when? Before the Sunday, before the prescribed time. You are saying, I will buy, ma'am, but you're not paying the amount. Then how can I hold it for you? It is not coming as per the terms and conditions. So this will not become a offer and automatically the offer lapses. So because of these 6 points, an offer can lapse. And the other heading for lapse, lapse means what? Overcome. What do you mean by this? Lapse of an offer means it comes to an end. Offer is given but is not valid hereafter. The other heading used here is often asked in the exam modes of revocation. In how many ways an offer can be revocated? Revocated is withdrawn. Yes, you can please make a note of it. We can go for the example also. What's the example? X offered to sell his bike to Y for 14,000 rupees subject to the condition that Y should pay an advance of 4,000. Before certain date, they need to mention about certainty. Y accepted the offer but did not pay the amount. So the offer stands. Okay. Miscellaneous, just to have an extra knowledge. Completeness of communication. Yes, actually have to bring to the knowledge of the offer. It's not just communicating. You have to bring to the knowledge of the offering. Special terms of an offer, probably like paying some token advance. And I say my offer will be valid till this date. See, my offer should be valid means I should mention the date, right? So probably like closing date of applications and all. So these are the miscellaneous headings. So offer is over now. The same like I have to go for acceptance. So far what we have done, offer we started with a definition. Can you please join with the headings? We started with the definition, then yes, please. We classified the offers. Remember what are the different types of offers? Then we brought this concept called as invitation to an offer. Then legal rules for an offer to be a valid one. Legal rules. How many rules we discuss? I think it's 9, right? 9 rules. 9 rules or 9 points or whatever it is. It's there in the act. Okay, it's not a general one, it's there in the act. Then we went for lapse of an offer. Okay. So these are the content we have covered. Along with this, we discussed when we were discussing along with lapse of an offer, we were discussing something related to revocation also. Actually, this heading will be covering this as one part. Second part, we'll be dealing with acceptance in detail. And third part, we are going to deal revocation in detail. Revocation will be dealing for offer and will be dealing for acceptance also. But for offer, I have already dealt. But even when I go for acceptance, I discuss. What we are going to discuss in acceptance? Can you please turn over the page and tell me what you're going to discuss in acceptance? We'll have a blueprint. This is what we are going to do. Yes, acceptance will actually define it. What's the definition? It's one single word. The consent given to the offer. That's it. Consent, saying okay. Okay. Then what else we are going to discuss there? General rules, which means as we discuss for validity of offer or contract, here we'll discuss for validity of a acceptance. Then third one, miscellaneous. I think only this is there, right? Modes of acceptance. Okay. Modes of acceptance. Actually, okay, modes of acceptance and miscellaneous. Then we'll go for revocation. Am I right? So revocation we have done with offer, we have to go with acceptance. So let me finish it off. Acceptance is nothing but the concern given to the offer. All these 3 points are very, very, very important. You can place as many star mark as you want. Only when a proposal is accepted, it becomes a promise. I have already discussed. Only an accepted proposal becomes a promise. Please, please don't forget this. When you talk only the offer, it will never be a contract. Only if you talk an offer along with the acceptance, then only you can talk about a contract, because offer is just a proposal. Only it is accepted, it becomes a promise. Okay. Second one, you can just leave it. Third one, a binding contract comes into existence on accepting the offer. So when we say a contract is binding, binding means what? It becomes a promise only on accepting the offer. So when this case goes to the court of law, the first and foremost point will be checked when the acceptance is given, whether the offer was valid during that period. If the offer was not valid during that period and the acceptance is given, then how can you say it's a contract? Because the offer is lapsed. Okay. General rules. First one, it should be absolute, unqualified, and unconditional, which means I'm saying 20 lakhs. Okay, you say 90 lakhs. No, it cannot happen. Unconditional means I'm saying that you have to pay 20 lakhs in lump sum. You say that I'll pay in 2 installments. No, that will not happen. Which means unqualified and unconditional means you have to exactly accept to my terms if I'm the offer. Okay, you have to exactly accept to the offerer's term. And absolute. This is what you call as absolute. Let me go for case one. B says I shall purchase if you buy my motorcycle for 50,000, I will purchase your car for 2 lakhs. But you have to buy my motorcycle for no. This is not absolute. Okay. This is what you call as conditional acceptance. I will accept, but you have to accept this one. No, you cannot say. You can deal this as a separate offer. That is different. B says I shall purchase if your documents are valid. B says I will purchase if your yes, obviously, right? I'm buying your car. How I'll come to know? You're totally new to me. How I'll come to know that it's your car? I need to know who's a valid owner. So I want to purchase. I want to check your documents before I go for purchase. Probably you might not be much worried about car. If you go for buying a property, definitely we'll have a take the copy of the original owner's documents, and who are the, like, we'll say the mother document and all. We'll check everything because we need to know the genuinity and validity of the owner, who's the existing owner. So I shall purchase if your documents are valid. This is unconditional, often asked in the exam. Especially CMA, you have to be very clear in this unconditional acceptance. Second, it should be communicated to the offerer, but this is not happening with general offer. This should be communicated to the offerer. Okay. Third, in which mode, pa? See, you don't see this as a separate heading. You have to continue with the offer. Then only you can understand. What's the third one? What we studied over there. It should be lapse of an offer. It should be in the prescribed or usual mode. Then it cannot call it as an offer. Here, the acceptance should be in the prescribed or usual mode. Else you cannot call this as an acceptance. It should be done within a prescribed or reasonable time. Else you cannot call this as a acceptance. Definitely, the fifth one is quite a normal point. You have to have an intention to fulfill the promise. Because once you're giving your acceptance means obviously it becomes a promise. Which means you have to have the intention. If you're not having the intention to fulfill the promise, how can you say it's an acceptance? Okay. It cannot precede an offer. Yes, please highlight this point. It's often asked. If there is no offer, how can I talk about acceptance? If an offer has lapsed, how can I talk about acceptance? See, I asked you to give your acceptance on Sunday. Okay. On Friday, I say that I am revoking my offer. This is the last case which I discussed. On Friday, I'm sending a note. I'm revoking my offer. On Saturday, you send a note. I'm accepting the offer. No, this is not at all possible. Once the revocation is valid, once it is revoked, we cannot talk about acceptance because the offer itself is closed. Now read this line. Acceptance cannot precede an offer. First, there should be an offer. Then only can talk about acceptance. That offer can be buying or selling. That's different. It should be given by the specific person to whom the offer is made. Obviously, to whom you are going to give this offer. That should be clearly mentioned, right? So again, you can go and refer Carlo versus Carbolic Walls. This is an exception case for general offer. General offer stands separately. It should be given before the offer lapses. And ninth one, very, very important. We can have this case law. M. Mo's Wise law. You remember? What was that person doing? L. This person is directly coming to your property and is starting moving. But what you are doing, you have to say no. You have to push him out. But what you are doing, you're silently watching it. Okay. Mental acceptance or silence is no acceptance unless inferred from the previous context. If you are asking, if you are not saying anything, means how can you say acceptance? In this case, M is moving, L is not, and you're not saying anything. Then you say that's an acceptance because it's an implied one. It's a conduct. You have to stop him because you have the full authority over the property. You have to stop it. And if you're not stopping him, you cannot say it's your wrong. Okay. Then you can go for this case law. 10th one, conduct or implied acceptance. A tradesman sending the goods on receiving an order from a customer. You buy anything in Flipkart or Amazon. The person you're not directly contacting, there is a platform called as a Flipkart or Amazon. You're placing an order over there. He receives an order. He doesn't know who are you. You doesn't know who is the person properly because of the star ratings and because of the many purchases you have done. You might be relieving, you may be depending that he might be a good seller. Okay, and you place the order. That person receives the order and just goes on. This is what you call as implied or contact, depending on the things happening. So these are the 10 points you can say an acceptance can be a valid. Can you please go through? Special, special case, I request you to go through. You can just go through a bit later. Small discussion only. I already have discussed this one. And I'll go for modes of acceptance. How can you accept? You can accept by an act, either written or oral. It can be positive acts, any signs or anything like that. By omission to do something. Anybody coming to my property and directly doing some work means how can I accept it? Okay. By conduct or forbearance. But only you have to check whether being silent is because in some business conduct is not normal case. In some business conduct, being silent should not be treated as acceptance. Okay. Sometimes being silent will be treated as fraud. When we discuss about this concern, we'll say that being silent is fraud about it. We'll have a different discussion over there. By conduct, by conveying an acceptance, see, board a public bus. It means you're going to buy the ticket. You're going to pay for it. It's understood. Dropping a coin in a weighing machine. You drop a coin in a weighing machine. The weighing machine is such a way uh, uh, done that if you stand over there and if you drop a coin, then obviously it's going to put a card weighing your measurements. Okay. And I'll go for miscellaneous completeness of acceptance. Actually, if this question is asked, you cannot use your own words. You have to use these words only. Let me go for the example, then I'll come for the content. A offers by letter to sell his house to Y at a certain price. The letter is posted on when, pa? 25th December. When it reaches 27th December, here the communication of the offer is complete when Y receives the letter. What you understand here? X offers to sell his house to Y at a certain price. So there is a certainty and all. The letter is posted on, who is posting? X. Posted on 27th December. It reaches on 27th, posted on 25th and reaches on 27th December to Y. Here, the communication of the offer is complete when Y receives the letter. It is not when X posted. When it's not been completed on 25th. When it is completed, when he receives the communication on 27th. Okay. Second, not a contract. In case you agree to sell your property in the future, at that time, what is the rate? What is the property? What is the market rate? You cannot say it's a contract. See, when we say a contract, certainty should be there. If you are not fixing up the terms by today, you cannot say it's a contract. Okay. You say, ma'am, I'm going to become a CA and CMA, ma'am. In 4 years, after 4 years, I'll buy a property, ma'am. I use the property for 1 year, ma'am. Okay. After that 1 year, I'll sell the property to you, ma'am. Losses is not a contract. Okay. Why means when you talk about the property should be in existence now, which means you have not yet bought the property. First thing, the property should be in existence. When it's about the property, you have to know about the land area of the property. When is the property you're selling today? You know the current market price, but you're going to sell after 4 or 5 years. How you know the market price? Okay. So there is no certainty. So agreement where you're going to agree the terms in the future. No, you cannot say it's a contract. You can just say it's an agreement and it's not valid. Contract, if you accept it by telephone or telex, yes, you can say as if you're sitting face to face and accepting it. Yes, you can say. Communication of special conditions. Actually, as of now, you can leave this one. Okay, probably later period I'll discuss. There's something called as tacit convey and tacit acceptance. As of now, I'm not discussing. Sometimes there is some special conditions. Means obviously you can refer that. Okay, probably this I later I'll discuss. I'm not overloading today. Standard forms of contract. Probably some situations may be there. Obviously, have to bring to a service. You are saying, ma'am, that you are willing to sell the car to me. I'm willing to buy, ma'am, but I don't know how to ride the car. Can you send it to my house? See, all the things has to be spoken before itself. Means then obviously we had to discuss also. So we cannot say this is not an acceptance. We cannot say this is a conditional acceptance, but instead what we say, we are just discussing this in future. That can be done. Okay. So this is done with acceptance. Can you please? So already started this concept called as revocation. What do you mean by revocation? Colloquial term is withdrawal, or we use the term taking it back. You can please make a note of these two terms, taking it back. Once it was asked in the exam whether cancelling a contract or cancelling an offer are valid. No, cancellation is the term what you call as rescinding. Rescind. Rescind. Rescind means you use with the word cancelling. Cancel. Rescind means cancel. Here, when we say withdrawing or taking it back, means it's what you call as revocation. See, you give something and take it back. That's what revocation is. It's a normal term where most of the cases we use it. Revocation can be discussed for both offer and also for acceptance. To discuss on validity, whether an offer is valid, whether revocation of offer is valid or revocation of acceptance is valid. If a revocation of offer should be valid, it should not be accepted. Why? Once it is accepted, it becomes a contract. Then how can you talk about withdrawing the offer? It's not possible. To talk about the validity of revocation of acceptance, it should not be properly reached to the offerer. It should not be properly reached to the offerer. It should not be properly communicated to the offerer. Let me discuss first, in this case, revocation of offer. Already I discussed the Sunday case. Before Sunday, you have to give the acceptance. On Friday, I send a note that I have revoked the offer. Okay, I have revoked the offer. I'll place a star mark. We have not accepted during that time because I have told before Sunday. Probably I might have accepted in the Friday morning also. Here I place a star mark, not accepted. If the offer is accepted, it becomes a contract. If the offer is not accepted, then the revocation will be valid. See, that can be one thing. Either revocation will be valid or contract will be valid. If the contract becomes valid, I cannot talk about revocation. If the revocation is valid, I cannot talk about contract. The other way. So this is what you call as revocation of offer. Okay, let me go for acceptance. Acceptance, you have to make a small note. Here, why I am sending a note by mail for the sale of 20 lakhs of selling my car. Please make a note to X, your X. Okay, you are willing to buy my car. Before Sunday, you sent a mail saying that you are accepting to buy this car. Okay, for what? 20 lakh rupees. But what happened here is, because of some emergency, you need that amount for some other purpose. You cannot utilize immediately for buying the car. For car, you can buy it later. But that's a very emergency purpose. You need this amount. So immediately you send another mail saying that I don't want to accept. Okay, don't want to accept. In this case, you call this as a valid revocation. You are giving the acceptance and you're withdrawing it. Okay, try to remember. Please listen here. If this is not the situation, you can scribble it later. Please listen here. If this is not the situation, the one I scribble in red color, directly you're sending a mail. This is the first mail. What you're sending? I don't want to accept. Okay, this is not at all an acceptance. When we talk about revocation of acceptance, please understand acceptance has to be sent, then it has to be revoked. What do you mean by revoking? Giving and taking it back. When we discuss about the offer was given, taken it back. Likewise, when we are talking about revocation of acceptance, acceptance should be given first, then it has to be taken back. Okay, if this is the first mail I'm sending, what's the mail? What the mail content is? Do not want to accept the offer. Then we cannot talk, or you need not talk about the revocation. There'll be no such concept called as revocation of acceptance, because revocation acceptance is not given. Then how can you talk about revocation of acceptance, right? So now I come back here. What I've done here, first you send the mail. This is the first mail saying that I'm accepting the car. Immediately you send another mail saying that I don't want to accept the car. Now the problem is those two mails has reached the person. Why has reached me? Okay. Law says is if both the mails come together, you take it as revocation. That is no acceptance. In case I received first mail, please note, I received myself. You send the mail to me. I received first mail. I did not receive the second mail. I received the first mail. I read the mail, which means communicated from your side, brought to my knowledge. When the communication of acceptance is complete, only when it is brought to the knowledge of the offerer. Who's the offerer? I am the offerer. You are the offeree. You are accepting, which means you are sending a mail. From your side, communication is over. But is that brought to my knowledge? It should be brought to my knowledge, which means I should have read it actually. Sometimes you might have seen probably after some 4 or 5 days, if you just open your inbox, mail inbox, you'll find that so many mails have been there. You have to pick one by one and then you have to read it. By sending this mail, communication is over. Communication is over, but it has to be brought to my knowledge. Okay. So what happened? I read the mail, the first mail which you sent. It says you accepted, the contract begins. After that, you immediately send, even though you immediately send the second mail saying, I don't want to accept it. The contract has begun. How can you talk about the revocation of acceptance? Please try to understand. When you can talk about revocation of acceptance, if the contract has not begun. When you talk about the revocation of offer, the contract has not begun. So you have sent the second mail where the first mail is taken to my knowledge, then the second mail, which is revocation of acceptance, is invalid because contract has started. It's a very deep concept. You have to understand. Please try to understand. Okay. I'll take over from material. So revocation, taking it back, or withdrawal. So it can be the cases related to offer and acceptance. Okay. Valid revocation means there is no contract, so parties become free. So no contract. Example, the same which I discussed. It's the same over here. You can refer later. Miscellaneous. Completeness of communication should be there. Okay. Acceptance is communicated. Okay. But is it brought to my knowledge? What do you mean by completeness? Means it should be brought to the other person's knowledge. Okay. Validity, it should be expressive only, no impliedness. Please make a note. This is often repeated. Probably it will be helpful for cases also. Expressive, it should move from the offerer. See, this is with respect to offer I'm talking. It should move from the offer. It should be of same channel. See, myself, why? I'm willing to sell my car for Shreyas. And who is the intermediary in between? X. I send the offer through X, which means also I need to send the revocation through X only. Should be of the same channel. Okay, it should be of the same channel and before the acceptance is complete. Whereas if you go for with respect to acceptance, revocation should reach offerer before acceptance. So obviously then only you can say it's a valid one. Sometimes it happens, both the mails are received together. Okay. And I find both the answers, which means what? Both accepted, both not accepted. What law says is you can consider as deemed revocation. If there are two mails, one is showing an intention to accept the offer, one is not showing an intention, means obviously your mind is not having the intention to accept the offer. So law says can consider as deemed revocation. So before or at the moment, you can expect this phrase in the exam before or at the moment together. So acceptance and revocation reach together. So you can go for this example also. I have discussed this example. So that's about this heading. We have to go for practical problems.